Good evening, everyone. Can you all confirm that you can hear me? Or can anyone confirm that they can hear me? Good evening.
Yes, sir.
Good evening.
Good evening, sir.
All right, good evening. I trust we're all great today. So we'll be starting right about now. Welcome to week 2 of our JIIPCC mentorship and internship program for the alternative dispute resolution course. Right. Our topic for today is mediation and career opportunities. And we have quite a lineup of mentors to carry us through today's topic. And I'm sure it's going to be a wonderful time in the session. So before we go ahead, I would just like to introduce our mentors. Okay, before I go any further, I would like to introduce myself firstly. My name is Dennis Williams, and I'll be your moderator for today. So we'll be going straight into introducing our mentors, and then we'll be taking mentees presentation, and after that, we'll now be hearing from our mentors on the discourse of today. So while we are reading our mentors profile, while we are reading our mentors profile and introducing them, I would like to kindly ask that group 3 and group 4, who are slated for presentation for this week, that they should get ready to start their presentation once we are done with the introduction of the mentors. So starting first, our first mentor for today that we're expecting on this call is Mr. Nyacham Namwan. Since I have read his profile yesterday, I was just reading a few lines of his and then moving to the next mentor. Right. So Mr. Nyacham Namwan is a lawyer and the principal partner of the law firm N. Nyacham and Co., a law firm based in Kaduna, Nigeria. He is a certified teacher, trainer, and facilitator. He is a faculty member and the executive director of Settlement House ADR Institute, an institution for training, certification, and practice of alternative dispute resolution. So Mr. Nyacham will be one of our mentors for today. I'm sure we were able to meet him last week, and I'm sure he would do a great job in helping us run through this particular session. Our second mentor that we expect on call today is Mr. Samuel Orobusa Osareren. Mr. Samuel Orobusa Osareren is a mediator, an arbitrator, a peace advocate, a negotiator, and a distinguished ADR practitioner to the core. He possesses advanced knowledge and understanding in peace and conflict advocacy, community mediation, family mediation, workplace conflict management and resolution, and peace building, amongst others. Right. So Mr. Samuel will be our second mentor for today. Kindly note that if you want to still go through our mentors profile, right, you can kindly visit our page, our LinkedIn page, that is JIIPCC. And then you will see we post our mentors profile on LinkedIn, on Instagram. You can just kindly follow us and you'll see a brief of all their profiles, and you can just kindly get to know them better. Our third mentor for today is Miss Eunice Olatunji. Miss Eunice Tolulope Olatunji is an accomplished legal professional and the lead counsel at Hepzibah LP Lagos, Nigeria, with expertise in business analysis, negotiation, mediation, and general dispute management and resolution. With nearly 2 decades of experience as a legal practitioner and a decade as an ADR practitioner, Eunice seamlessly integrates legal knowledge with business acumen to provide holistic solutions. She holds an MBA from Obafemi Awolowo University, Nigeria, and a master's in mediation and conflict resolution from the University of Strathclyde, UK. So Miss Eunice will be our third mentor for today. Moving forward, our fourth mentor that we'll be expecting on this call is Ms. Duruti Kapadia. Sorry, Ma, if I didn't pronounce your name very well. Ms. Duruti is currently here with us on the call, and we'll just do well to run through her profile quickly. Ms. Duruti, teaching teaching law at Mumbai University Law Colleges, 13 hours per week, training students for alternative dispute resolution, chief guest and judging moots in various universities, took up an independent matter against BEST and won the matter, placed second in the Just Ice Moose 2008 representing Government Law College, topped first year law 2004-2005 with an aggregate of 69%, won couple of certificates in sports, ranked as a competent skater, judged debate competitions and trained students for international mediation, worked for representation and knowledge management of the firm, worked on 2 presentations for the firm's knowledge management, attended seminars on real estate, has settled litigations referred in Maharashtra, Lok Adalat on panel as a selected member, wrote a research paper with ISBN number in legal proceeding, has been interviewed by media, and has contributed articles on legal subjects. Times of Indian newspaper has reported her name in the case. She has succeeded for a student's admission in medical college. Times of Indian newspaper and other leading newspapers has reported her cases she has succeeded. Articles written by her are published in leading newspapers. Welcome, we are happy to have you here with us on call. We are really excited for you to join us in today's session, and we hope to hear from you very soon. Still moving on, our fourth mentor, if I'm not mistaken, fourth or fifth mentor for today is Mr. Joseph Shiaidon. Mr. Joseph is the team lead as Strengths and Blanks partner. He leads the firm Arbitration, Maritime Construction, and Energy Disputes Practice Group. He is a graduate of law from the Niger Delta University and the Nigerian Law School. Joseph has extensive experience in arbitration and commercial litigation. He has acted as counsel in several international arbitration and arbitrary award enforcements, proceeding under major arbitration rules, including ICC, DIAC, UNCITRAL, MAAN, and RCICAL. His focus is on providing cutting-edge strategies for resolve disputes in areas of maritime, oil and gas, commercial contracts, construction, corporate debt recovery, bankruptcy/insolvency, and civil fraud/white-collar crimes. He's also experienced in advising clients in relation to concession contracts, joint venture agreements, maritime asset acquisition, due diligence, and distress situation deals. Our sixth mentor for today, sorry that this is taking quite a while, right? We have such a power-packed session waiting for you, so please kindly talk in and just get ready to hear from our very distinguished mentor. Our sixth mentor for today is Miss Mispa Fra Awasum. Miss Mispa is a distinguished Cameroonian professional specializing in international arbitration, mediation, and consultancy, with an extensive academic background that includes an LLM, MSc, and ongoing PhD study. She is a recognized expert in her field. Mispa holds several prestigious qualifications, including membership in the Chartered Institute of Arbitrators, a fellows of the International Mediation Council campus in Germany, and ICCYAAF member. Ms. Mispa is our sixth mentor for today. I'm not sure if she's yet here with us, but I'm sure she'll be joining us very shortly. Welcome, Ma. You're very, very much welcome, Ma. Our last but not the least of our mentors for today is Mr. Toyid Amuda. Mr. Toyid Amuda is the founder and managing partner as Lawvocate, Attorney, a firm of lawyers, investment consultants, and arbitrators. He is an international commercial dispute attorney and an investment consultant. He has significant experience in commercial litigation, commercial arbitration, and investments treaty arbitration. He holds a Master's of Law (LLM) degree with distinction in international business law from the University of Law in London, United Kingdom. He has written a significant number of articles in the dispute resolution space and holds several awards. His experience is multi-jurisdictional. In his role as an investment consultant, he regularly assists business in raising capitals for their expansion, ranging from private equity to venture capital. So thank you, Mr. Toid Amuda. I think he's here with us on call. I'm not so sure, but we should just kindly talk in. We would be starting our program for today shortly. And like I said, we have a Power Packed program session ready for you. So just sit in and enjoy the ride. So moving on, like I said, we'll be having presentations from Group 3 and Group 4 before we move into our mentors' presentation. So please, because of our time, we don't want to spend so much time on call. We will try to see how well to beat the 2 hours time frame, to stay within the 2 hours time frame that we have set for class. So please, Group 3 and Group 4, Group 3 presenter, kindly unmute yourself. Your presentation is for 7 minutes. Please stick to time and let's move on. Thank you. You can share your screen as you present.
Good evening, Mr. Williams. Good evening, sir. I'm the presenter for Group 3.
All right, thank you very much. Please, you can go ahead and share your slides and start your presentation.
Good evening. I want to confirm if everyone can see the slide.
Not
Yes,
yet.
I can see. Good.
Okay.
Okay, thank you, ma'am. Okay, I'll begin the presentation now. Good evening to our esteemed mentors and my fellow mentees. My name is Obakbe Sosa. I am the backup presenter for Group 3, and today we will be presenting on the topic Mediation and Career Opportunities. This presentation covers 5 main aspects of mediation, namely the principles, stages and processes, the agreements to mediate, the settlement agreements, and career opportunities in mediation. Before I begin, I believe it is very important to give a brief definition of mediation. Now, mediation is an ADR process involving 2 or more parties who come together to resolve a dispute with the help of a neutral third person called a mediator. The mediator's role is like that of a referee. He does not make decisions like a judge or an arbitrator. He or she simply helps the disputants to evaluate their goals and arrive at an equitable solution. Okay. Having defined mediation, I would like us to look at the key principles of mediation. They are clearly highlighted here in the slide, but I will elucidate more on the most pressing ones. Now, on the principle of confidentiality. Confidentiality ensures that all decisions between parties remain private and protected. This is a great benefit to parties such as commercial organizations, as it provides an avenue for them to resolve disputes while keeping the confidential details of their agreements private. On to the principle of neutrality. The mediator acts as an unbiased facilitator. He is essentially there to protect the interests of both parties rather than taking sides. In terms of voluntary participation, disputants can voluntarily participate in a mediation process. They do not need to be forced or coerced before they take part in mediation. We also have creative solutions. Due to the flexible nature of mediation, the mediator can suggest new and innovative options that meet the needs of both parties. We also have the principle of following up. In line with the empathetic nature of mediation, it is quite common for mediators to schedule post-mediation checkups to ensure that parties follow up with their agreements. Dwelling more on voluntary and confidential nature of mediation. Okay, we have various aspects under this. We have confidentiality, self-determination, informal process, neutral mediator, preserving of relationships, and cost effectiveness. I've already talked on confidentiality, so I'll move on to informal process. Now, generally, litigation is a highly formal process involving a lot of formal rules and procedures. However, mediation offers a more informal process, flexible procedures that can easily be adopted to fit the needs of the participants. Also, in terms of preserving relationships, there is a common saying that parties who go to court never return as friends. This is because at the end of every judgment, we always have a winner and a loser. However, mediation offers a win-win situation for both parties, thereby creating an avenue for relationships to be preserved. We also have cost effectiveness. Now, in our last session, Mr. Samuel Orobosa talked on cost effectiveness. He stated how cost effectiveness isn't based on whether a process is cheap or expensive. Rather, if a party had to spend a lot of money and it was able to acquire a very speedy judgment, to that party, such a process is cost effective. These are some of the major benefits of mediation. Now, the next aspect is on the stages of mediation. There are 7 main stages involved in mediation. Firstly, we have preparation. This stage involves the gathering of necessary information for mediation. It includes identifying the main issues between the disputants. We also have introduction. In this case, just like in any court proceeding, the parties will formally introduce themselves. The mediator explains the processes and ground rules in this stage as well. Onto statements. This is the point where both parties present their opinions on the dispute in order for the mediator to know the facts of the dispute. We also have clarification. The mediator asks questions aimed at clarifying the issues presented. In line with negotiation, as an initial step in ADR, the parties come together to generate possible solutions for their issues. Under agreements, after negotiating, parties agree on terms to resolve the conflict. And then lastly, we have closure. The mediator comes in and summarizes the agreements. After this, he concludes the session. These are some of the major principles and major steps under the stages of mediation. Next, we have agreements to mediate. Now, an agreement to mediate, or simply put, a mediation agreement, is a written document between the parties involved, the mediator, and any other legal advisor participating in the mediation session. It is a document that regulates and legalizes the whole mediation process. It essentially comes before the mediation takes place. This document outlines very crucial components, such as the appointment of the mediator, the roles and obligations of all parties, details of the mediation process, and most especially, it specifies that parties have chosen to resolve their disputes through mediation rather than litigation or arbitration. On to the next aspect, we have more on understanding agreements to mediate. This outlines the essential benefits of agreements to mediate. They establish neutrality, they set clear objectives, they define confidentiality terms, and also they outline participation rules. Moving on to the next aspect of this presentation, terms of settlement. A term of settlement is a document created after a successful mediation, and it serves as a binding contract that specifies the agreed upon terms for resolving the dispute. It is basically a document drafted by the mediator after a mediation session. It outlines key components such as identification of parties, summary of the dispute, specific settlements, payment provisions and methods, confidentiality clauses, as well as the laws governing the agreement. To expatiate more on this, we have a diagram which highlights some of the key components involved in the terms of settlement. In terms of agreement summary, it gives an overview of the key points, it clarifies the main terms, and therefore it ensures mutual understanding between disputants. We also have payment terms. This basically states the amounts to be paid in terms of compensation, as well as the methods to which such payment should be made. This is beneficial because it provides financial clarity, and it also reduces the chance of parties resolving to other measures of dispute resolution in the future. Confidentiality clauses are also ways for companies or commercial organizations, individuals, or other disputants to stipulate that they do not want the details of their proceedings, the details of the mediation session to be shared with the public. And of course, duration of settlements. It specifies a time frame for the execution of the agreements. This ensures that expectations are set and it creates accountability between the parties. Finally, we have career opportunities in mediation. Now, mediators can work in a number of sectors, including legal firms, corporate environments, and community organizations. However, mediators are required to possess certain skills before they can embark on such journeys. These skills include communication skills, conflict resolution skills, empathy skills, interpersonal skills, and of course, negotiation skills. This ensures that they thrive in a multidimensional and dynamic environment. In relation to these skills, they can be acquired by taking courses and getting certified by recognized ADR bodies, such as the Chartered Institute of Arbitrators, the Chartered Institute of Nigerian Arbitrators, and our very own Settlement House ADR Training Institute. All these ADR bodies offer an avenue for people to get certified with the necessary skills to become mediators. Now, for the career prospects in mediation, we have the professional mediator. He or she facilitates disputes in various settings, such as courts, organizations, or private practice. This means a professional mediator can work in both public and private settings. We also have the conflict resolution specialist. He or she works in organizations to resolve internal conflicts and improve communication. Any organization can have a conflict resolution specialist. A law firm can have a conflict resolution specialist. He or she will resolve disputes between employees or between the employee and the law firm itself. Also, we have a negotiator. A negotiator facilitates agreements between parties in business, diplomacy, or other fields. We also have the conflict coach. He or she helps individuals develop strategies to manage conflicts. That means an individual, an organization, or any other body can have a conflict coach to help he or she manage conflicts. On this note, I would like to conclude by speaking on the future of mediation careers. Now, with so many factors involved, we can see that mediation has a very bright future with its increased demand, diverse opportunities, avenue for skill development, and as well as with the use of technological integration. To emphasize more on this, in terms of increased demand, there is an increased demand in mediation as organizations are seeking cost-effective means of conflict resolution. In terms of diverse opportunities, there are diverse opportunities in mediation, such as corporate roles and even independent mediation practices. There is also an avenue to continuously develop skills in mediation. Finally, by embracing technology, we can be rest assured that there will be continual growth and continuity in mediation. And that marks the end of our presentation. Thank you very much for listening.
All right, thank you very much. Sorry, I'm trying to guess your name. Esosa, right, if I'm not mistaken. Yes, thank you so much for your presentation. Well done to you and your group members for putting together that wonderful presentation. Next, we'll be having group 4, right? So group 4, please, if you're ready with your presentation, come up and make your presentation. Time frame 7 minutes. Let's do that as quick as possible so that we can start hearing from our mentors. So thank you. Kainde, are you the group presenter? Okay, please, can we have the presenter for group 4? Please, we would like to have that quickly. Group 4, do we have members of group 4 on this call? Please, we do not have all day. All right, we will not be wasting any time. Okay, before we go on to our mentor's presentation, right, because I know quite a number of us are in places where the our lighting may decrease with time. So please, I would like to kindly ask for us to turn on our video so that we can take a quick screenshot so that we don't have to deal with poor lighting towards the end of the class. So please, if you can you kindly turn on your video so that we can take a quick screenshot and then we'll move on. All right, please, just a minute. All right, thank you very much for that. We're done with the pictures. So thank you so much for cooperating. All right, so we'll be going into business proper, right? Our mentors have heard from Group 3. Group 3 was able to make presentation. We hope next time Group 4 will be able to eventually have their presentation. We'll try to deal with that within their group. But for now, we'll just be going straight to hear from our mentors so that we can hear from them and see how well we can increase or improve our knowledge in the line of mediation and the career opportunities that are opened for those who are enthusiasts or who are interested in this particular area. So firstly, I'll be giving the floor to Mr. Nyacham so that he can help coordinate this period, this particular segment of this section. So Mr. Nyacham, over to you, sir.
Thank you very much for that wonderful opportunity. And Obokpe Esosa, thank you very much for that presentation. I also want to use this opportunity to appreciate all our mentors who are here with us. Now, I want to appreciate Group 1 for that wonderful presentation. I can see the person who prepared the slides is very professional, and the content has been very, very good and very, very well arranged and captured. So I think they deserve some kind of award, so to say. So having said so, I believe that some of the participants of that group should be able to take advantage of settlement house training, mediation certification training coming up. I will be very, very much willing to see how we can assist that group to take advantage of that training. It's between 2nd to 6th of September, and I will be happy to do that. So having said so, that presentation and the content actually captured some of the things that we needed to. Let me acknowledge the presence of my colleague and mentor, Mrs. Kapadia, all the way from India. We are happy to have you. You know, when I saw the profile, I was like, I didn't send this profile to him. How comes? You know, I was wondering. So thank you very much for showing up, and we're happy to have you. Now, unlike what we did last week, we believe that the participants have made a good research, and so we will rather prefer to have the participants ask relevant questions, valuable questions that they encounter in the course of their research, and putting their papers together, so that we can now attempt the question. Let it be a learning that is let's say value-based and as required. So let us open up the floor for participants who have listened to their presentations and members of that group. Do you have any question? We have looked at varieties of things. We looked at mediation, which was properly defined. And we also looked at mediation and career opportunities in mediation. They define mediation for us, and then they help us to understand that mediation has principles, And those principles they've mentioned, usually people go for like 5 major, and then there are others. And they've mentioned a lot of principles for us, and that is good. And we have the stages of mediation. These are the major things that you need to know, the stages of the mediation, from one stage to the other. And then before you commence your agreement, your mediation session, there is what is called agreement to mediate, so that parties will be sure that, yes, they are at the right place and they have committed themselves to a process that they are going to discuss. And then they have also looked at that agreement to mediate. You do that before you commence the session, and then they looked at career opportunities in mediation, and they considered ADR institutions, and then the future of ADR. So these are some of the things that they covered. I want to hear if any one of you have any pressing question that you want to answer. We'll answer some of the questions, and then we can make our final remarks on some of the things that we feel should be added. That would be more preferable, so that everybody will be able to have value for his time. Mr. Dennis, I hope we are all on course.
Yes, sir, we are. Yes, sir, we are. All right. I can see Jean. John, I think someone corrected me on the pronunciation of your name. So Jean-Marie, if you're with us, please, you can go ahead and ask your question.
Yes, sir. Can you hear me now?
Yes, I can hear you clear, loud and clear.
Okay, thank you very much. I was about to ask a question regarding to the styles which mediator can conduct. What I mean is styles that any mediator can conduct, so that to have an effective outcome.
Okay, thank you very much, Mr. How do you call your name? Jean-Marie? Jean?
Yeah, of course. Ramali.
Ramali.
Ramali. Yeah.
Thank you. All right. The question, should we attempt the question or to take the questions first before attempting, or attempt question as they come? What do we suggest?
I think we should take the questions as they come, sir.
Okay, that's fine. So Barrister Kapadia, are you with us?
Yeah. Yes, I'm very much here.
Yes, you heard his question. So would you like to attempt the question?
Yeah, sure. What is the question? I can just get to hear again. Like, what's your question?
He is asking what mediation styles, would a mediator take to be able to have an effective mediation? And by style, I believe I think it's referring to maybe the processes
Okay.
of the mediation that you can adopt for effective mediation.
Yeah. How do I get the question? I can answer it very briefly and very interestingly. A mediator has to be a neutral person. So firstly, when he has started the session in mediation, he must make sure the parties have trust in him. In that sense, show the neutrality completely. And also to discuss that there is everything that discussed in the session would be confidential in nature. B, the second style which he has to be persuasive to is about active listening. There is a difference between hearing and active listening. Active listening would be when a party is speaking, the mediator has to be focused in hearing what actually the party desires to talk and what is party expecting from the other party in order to make the mediation successful. Therefore, supposing when I am talking, somebody else interrupts me, it is purely a disactive hearing. Therefore, the active listening skills are very, very important. The communication and the language together have to be very, very simple and to the point. Many a times, parties drag it out because they're emotionally connected. They have their own ways of putting their own negotiating skills before out. And mediator has to be a facilitator to ensure that there's no impasse. Now, what is an impasse? A failure of mediation should not take place. Therefore, he should make sure the parties, maybe in a private session or maybe in a joint session, speak up of what they really want. So,
Sorry, ma'am. Sorry, the participants, if you cannot speak, you can drop your question on the
yeah,
box.
chat box.
If,
So
but
that's,
if
yeah.
you
So
can
this
raise,
is all what I wanted to say. Thank you.
oh, okay, that's good. Thank you very much, Mrs. Kapadia, for that contribution. Now, in addition to what she has said, if you are looking at the processes, like you want to start up a mediation session, you want to look at processes you need to follow. What Kapadia has said, those are cardinal things that you have to observe and do in the course of your mediation. But if you are looking at something from stage to stage, stage one, you need to prepare. Preparation is key. You cannot have a mediation session, you don't know what you need to do. You need to know where you are going to meet, the venue. You need to know the timing. You need to know whether the mediator is going to be traveling, whether he's going to be sleeping over in a hotel or some of those things. These are preparation. Then if you have a file, it is good for you to look at the file and read up the information in the file. What is the person that initiated the mediation? What is his complaint? What is his issue? If the other person has also responded, what is the contention of that person, so that you have an idea what it is. Some people argue that it is not necessary for you to read up the file because it may make you to begin to have a kind of biased mindset. But that notwithstanding, depending on the type of a mediator you are, if you prefer to go into the session so that you can hear firsthand from the parties, that will be good. But if not, you can read up the file to understand. So part of your preparation is to develop strategies. Assuming these people get into an impasse, what am I supposed to do, right? So you can, from the names of the parties, if it is a company, if it is a business, you can decide to prepare. You can decide to prepare by making some little research about the parties involved, so that the knowledge you have about the parties will help you understand what they value most, because you want to, like Kapadia say, you want to build trust. You want them to trust in you to assist them. So what you need to do is to ensure that you give them that opportunity to be able to, you give them that opportunity to develop trust and confidence in you. If they cannot trust you, it means that it cannot work out. It will be difficult for them to allow you to help them resolve your dispute. Are we together? Are we together?
Yes, sir.
Are we together? The next stage is,
yes, sir.
Yeah, the next stage will be that after you do a preparation, you come to the mediation table. At the mediation table, what you need to do is to start by your doing your opening statement. Like Kapadia has said, a mediator has to give an opening statement. Opening statement is important because the parties sometimes don't actually know what mediation is. They have never been to a mediation table. They don't know what is even happening there. They will even be thinking that it is another court. They just say you should go to another court. That's what they may be calling. So at the opening statement, you introduce yourself and your qualification and where you have been certified. Like, oh, I am Nanchang. I've been certified by Settlement House ADR Training Institute as a mediator. I've been practicing and I've helped parties resolve dispute in this field, for some time, right? The parties will begin to look at, oh, so this person has the necessary expertise. Then aside from that, you help them to understand the key principles of mediation, things that are valued in mediation. So the issue of neutrality, confidentiality, so that they can develop their trust. They will be free to discuss and share, knowing fully well that. Hello, can you hear me? Can you hear me?
Yes,
We can hear you, sir.
Yes, you can.
Yes, sir.
Somebody
Okay,
has a
so
question.
can you hear me?
Yes, you can.
Yes, sir, we can hear you clearly. Can hear you clearly. Yeah.
So now you look at the opening statement, so that the parties, you get to ask them, have they been in a mediation session before? If they have not been in a mediation session, then you help them explain what the mediation is, the processes they are going to follow. You may have a joint session, you may have a private session. Explain to them, you are not taking decision for them. Everything you discuss is going to be free and confidential, and they should not be afraid of maybe this person will go and use the information in court. So this is one of the things you need to do in your opening statement. When you finish, you should agree on ground rules. Those ground rules are what will help you, and do it collaboratively. Collaboratively in the sense that, don't say, for example, you need to put off your phones, nobody should pick any call here and all of those things. It's voluntary. The parties will decide to get angry and leave. But when you tell them that, okay, for us to have a good conversation, we are expecting that we try to avoid distraction. We try to avoid possible distraction. So it will be good for us to have our phones on silence. So what do you think? They say, oh, that's good. But if you have an emergency call, maybe you can just take an excuse, so that will excuse you to go and pick your call. Try to set the rules and the standards collaboratively, so that everybody can own the process. Just like mediation, it helps the parties to own the result at the end, because they are the ones deciding. So help them to know that they are going to do the conversation, they are going to do the negotiation, they are going to take the decision, they are going to craft a result that is suitable for them. That is at the opening stage. After your own opening statement as a mediator, the parties will give their own opening statement. And their opening statement is simply telling you their own side of the story. This is why I'm here, this, and that. When you finish, the other person will also be called upon to. So part of your rules will be that, please, when one person is speaking, let the other person not interrupt. So that when you have any issue you want to talk about, just identify it, write it down, so that when it is your time to speak, you can address it. Those are part of the rules. So by the time both of them have finished their opening statement, you'll be able to have an idea. So collaboratively also set an agenda. Are you understanding the processes, please? Yes. Collaboratively set a standard, an agenda for discussion. Let's say it is a business dispute where the parties have agreed, I gave you 1 naira to supply 1 bag of rice, and you did not supply. The issue of contract, I have given you 1 naira to supply a bag of rice. They are not in contention. The issue in contention now will be, okay, you did not supply the bag of rice. So that can be an agenda for discussion. Why didn't you supply it? I need my money back, or I need a bag of rice and I need damages. Those are issues that are contentious that you need to form, that will form part of your agenda. Once you form an agenda, it will now be easy for you to go into pick those agenda one after the other and get the party's resolution. After the opening stage, you form an agenda. After you set an agenda, you go into exploration. Exploration is there. That is where you begin to do a conversation to be able to understand the underlying interest. Somebody may just be that, okay, his own issue was that it's not even the issue of the money or the supply of the bag of rice that is his problem. Is that this person is rude to him and he wants to teach him a lesson. So you go into an exploration stage where you are going to explore the interests of the parties, get to understand, where necessary, you break into caucuses so that you can have personal discussion with the parties. After that, we now go into negotiation. The negotiation stage will be simply you are bringing the matter to a conclusion. Now, what do we do? How best do you think we can resolve this issue? Say, so since he has spoken, I even understand the reason why he failed to supply. Can he return my money? And the other person is saying, okay, yes, I will return it, but I need more time. Are we together? So that's negotiation. Okay, what time do you need? Oh, I'm a salary earner and they pay me only at the end of the month, and I can actually pay when the months end. You know, so that's negotiation. If the parties have negotiated and they now find a settlement, you document some of this thing down. You go to your conclusion stage. At the conclusion stage, that is where you are going to now draft the agreement to say, oh, this party has agreed to refund back the money or supply the bag of rice within so period of time, and this, and that. That is what you call your terms of settlement. And at that, you have come to the end of it. So your agreement to mediate will be at the beginning before you start, so that your fees and all those other things will be agreed, the confidentiality, discussion with your discussion with sincerity, without any manipulation, you know, and all of those things will be stated, you know, so that the parties will sign. They will not tell you that, okay, what do you say about this? And say, actually, I was just here. I wanted to hear what you people have to say and the thing. Now that I've had, okay, I will get back to you. No, they have to sign that agreement to mediate before you commence, so that at the conclusion of it, you are going to have a terms of settlement. I hope we have attempted your question. Mr. Jean-Marie, your name, I cannot answer your question, right?
Yes,
Yeah.
we're covered.
Okay. Thank you very much. Thank you very much for that. So we now have Musonda Molaisho. Musonda Molaisho, please, can you ask your question? Musonda Molaisho.
Yes, thank you so much. So my question is, we've been talking about the benefits of mediation. We talked about how good it is compared to litigation. So now my question is, what are the limitations of mediation, and what are the disadvantages of mediation?
Can your voice be louder?
Okay.
So
okay.
are you able to hear me?
Yes, I can hear you.
Okay, so my question is, we have talked about the advantages, the good part of mediation. So now I would like to know if there are any limitations with regards to mediation, and if there are any disadvantages at all.
Okay. So thank you very much for that wonderful question. I want to know if there is any disadvantage. Mr. Samuel. Samuel, Your Excellency, sir, we're happy to have you. Thank you very much for joining us out of your busy schedule. So, Ambassador Samuel, one of the participants, wants to know, we have learned about the advantages of mediation. Are there disadvantages?
There are different schools of thoughts when you talk about advantages of mediation. So persons will tell you one of the disadvantages that is party friendly. So at the instance of parties, it is parties that have to decide whether they are settling or not. But some school of thought will tell you that that is not a disadvantage, but rather an advantage. Giving parties the privilege to decide on it. So I want to align myself with the fact that disadvantage for my school of thought. Another school of thought will tell you that enforcement of settlement agreement is not 100% holistic. Now that depends on the institution or the methodology adopted in the settlement agreement. If you engage a private dispute resolution center to enable you resolve your dispute, at the end of the day, the settlement agreement may not be enforced. But if you route it through a multiple courthouse, the settlement agreement can be processed and taken through a system whereby it becomes a consent judgment. If it is a consent judgment, then it can be enforced. So depend on the school of thought. With all humility, some legal practitioners, I had an encounter with one, and he said mediation should be a last resort and not a resort. From his own angle, he's thinking that when parties must have exhausted all other means of settlement and they are now weary and exhausted, they can now resort to mediation. But on school of thought will tell you, why waste time and resources exploring different options instead of coming first to mediation? So in answering your question, it depends on the school of thought we tend to align with. I am of the opinion that mediation does not have any form of disadvantage. The fact that there's a settlement at the end of the mediation does not mean it's an advantage. The fact that there's no settlement, parties are unable to resolve, does not mean that mediation has a disadvantage. Whether they resolve or not, the essence of mediation is making parties understand, bringing them to the table where they're able to sit, understand some underlying issues, and have the ability to decide how they want to handle the issue. So I may beg to differ by saying there is no disadvantage in mediation. The beauty is in the process, and that is why when parties are made to pay for a mediation session, they are not paying for the output, they are paying for the process. We always explain that to them. You are not paying for the settlement at the end of the day, or that there's not going to be settlement at the end of the day. Your payment is for the process you're about to go through, which is dynamic and unique. I don't know if I'm able to answer your question. When you sample opinions,
yes, thank you very much, sir.
you get different school of thought. Thank you, sir.
Yes, thank you very much. I think you have answered the question. There may be instances where you will see that mediation is not involved, where there are serious criminal offenses like maybe capital offenses like rape, murder, and all of those things. You don't mediate some of those matters. Although you have mediation in simple offenses, restorative justice, among others. So take note. And then mediation is not used to resolve or to dissolve a marriage. You cannot use that to dissolve a marriage. You cannot use it for declaration of rights. Those are duties of the court. So that may be, this may be a kind of limitation, so to say. But every other issue surrounding it, can be resolved via mediation. And more so that it is the parties themselves that resolve the matters by themselves. It's not any other person. So that's very, very important. I saw one of our mentor, Eunice. You wanted to say something in a few minutes about that, or you attempt the question, the next question by on Yin Kansola or Yin Kansola or Yin Kansola.
Onyi Consola.
Okay, on Yin Kansola.
You don't
I'm learning a
massacre
lot.
that name so that we don't start mediating on the name.
Oh, pardon, please, I apologize. Yes.
Good evening. I'm sorry I'm joining late and I will see dash out quickly. But just to add to what everyone has said about the benefits or the merits of mediation, I see I think I align myself with every other speaker that has spoken. There is no demerit. The demerit that people may say is the fact that it's voluntary. Where people say, oh, I don't want to mediate, then you cannot compel them, which is why so many people are advocating for mandatory mediation. Some of the school of thoughts do not agree. Like me, I do not agree in mandating people to do mediation because it takes the essence away. But in a way, it has its own benefit, especially when it is called mandated mediation, and people are able to reach amicable resolution. For those who are in legal practice, you know that settlement that is reached through mediation, and entered as consent judgment, cannot be set aside on appeal, which is another benefit of having a mediation. Yes, because parties are bound by it. You cannot appeal it like any other judgment that, I do not agree with this judge. You have consented to it, so it's not appealable. So it is very, 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 very better compared to others, even better than arbitration. The arbitrators may not agree, but settlements reached by mediation, especially if it's court-referred mediation, is better than every other means of resolving matter. Thank you.
All right. Thank you very much, Eunice. We appreciate you. In fact, I, in the voice of the ambassador in the house, we appreciate you greatly. Yes. I wish I can borrow his
I
voice.
appreciate you, Eunice. Thank you.
Thank you very much. Thank you. Okay, so now the next person raising his hand here is Oyin Kasola. Please, can you ask your question?
Good evening, everyone.
Yeah, good evening.
On like a session like this on ADR, if I become a mediator or after becoming an arbitrator, let me say, what would you say is the next step to becoming a non-arbitrator? Because like, would I have to work in a multi-door courthouse first, or what would I do to become a non-arbitrator after becoming an arbitrator? So yeah, thank you very much.
Sorry, I don't understand. You want to become a non-arbitrator?
Yes, my question is, after I take a course on arbitration and then I have an arbitration case, like I'm a satisfied arbitrator now, how do I go about, like, how would I settle sessions and all those things? What would be my next step from there? Would I work in a multi-door courthouse first, or what would you advise is the next step after becoming an arbitrator? Thank you.
Okay, so thank you very much for that question. Mr. Samuel, you work in a multi-door courthouse. I think this question is directed to you.
Yeah, thank you, Professor Nachang. The question is actually directed to us, and I think we will all have a piece of it. I think your question, if I'm correct, you want to understand how to make progress after doing the training. Is that your question? Yeah.
Yes.
I want to appreciate you noting the fact that you are being futuristic. You are not just seeing yourself going through this mentorship training. No, you want to actually get into the field, and that passion must be sustained. That is one. Now, going forward, when you've done your training, I think I and Uni spoke on this. I think a related question to this in the last set. You've gotten the skills, you've gotten the training, you've gotten the knowledge. What next do? You can identify mentors that you can work with, gaining practical experience. Because, like I said last week, if you remember, whatever you go through the process of training, there may be a little difference when you get to the field in terms of practice. There are some things that may not be encapsulated in your training manual that you encounter in practice. So look for mentors that you can work with that will mentor you. Now, talking about the multi-door court houses, I think the multi-door court houses like we have in Nigeria, as it were, is next to the High Court of Justice in states. That means you may need to be a civil servant, as it were, to gain access to those civil courts and multi-door court houses. But we have private dispute resolution centers. So you can locate any private dispute resolution center, see how you can work with them, or better still, there are different engagement that goes on. You can render your pro bono services. Render your services pro bono. Oh, this is what I do. This is what I can do. How can I be of help? And that is why we are partnering with SHATI, Settlement House ADR Training Institute. They have a lot of activities going on. When you see Mr. Nachan, he's a representative of so many institutes, both national and international. So we can liaise with him, reach out to him and the different mentors on the call I think I need to do this. I think I need to do that. What activities do you have? How can I be of help? What services do you have? How can I assist you? Now, the question is, know that as a mediator, as an arbitrator, that may not be your primary core competence. You may have your primary competence in whatever vocational skill you have. That is an added advantage. What can you bring to the table? Are you into graphics? Are you good in mass communication? Are you good in report writing? Are you good in grant writing? So whatever you have, how do you add value to the process? I may not be exhaustive in my answer, but what I want to emphasize on is you don't throw away what you have because of what you think you want to get. Whatever vocation you have, whatever skill you have, whatever discipline that you are in, you can bring it on board to add value to the process. Finally, locate a mentor, grow under a mentor, locate a dispute resolution center, see how you can identify with them, pro bono, attend webinars, and most importantly, being a mediator or an arbitrator is not the end of the learning process. If you ask the mentors in the house, ask Eunice, ask Nachang, they will tell you how much more money they have put into their training. You need to do a whole lot of trainings after your first level of training. This training does not only enable you to gain competence, it also enables you to network with other professionals. Somebody said your network is your net worth. You get to know more persons, improve your social circle, write articles, do publications. Then you can take advantage of the social media space. A lot of young persons put all manner of things on social media space that mean nothing. You can be creative in your posts, be creative in your status. I never can tell. One thing will lead to another, and you start flying. I always tell people, I came into the world of ADR about 4 years ago, and look at where I am today because I deliberately decided to impact on myself and make a change. You may be fortunate enough to have a law firm that you can partner with. I don't know if you're a lawyer by default, but if you have your chambers, you can do ADR services along with your legal services. Or on a personal note, I had to register a business name under the CSC that can cover my ADR services and ADR activities. There's so much you can do. I think I need to allow other mentors come in. I don't know if I've made any sense at all.
Thank you very much. In fact, I wish I am your student. I wish I had this opportunity. I didn't know why I didn't meet you in time. His Excellency, the Ambassador. Thank you very much for that contribution. Kapadia, I don't know. Are you with us, Kapadia?
Yes, I'm with you all. Tell me.
Okay, please. You have had the boiling discussions in the house. Will you want to say one or two things?
I want to say four things, not one or two things. Yes, four things. Most important thing to get a very bright career in ADR, say it in arbitrator field or say it in mediator field, one has to be thorough with their own strategies of what they want to do out of being an arbitrator and out of being a mediator. Once you understand that mediation is not just commercial, but a social healing, you will be devoting more of your own self into putting into those activities which will enable people to get a result-oriented solution. So how do you do this is the question. First important thing is get yourself trained. Once you know what it is the subject like and you have well accredited training done internationally or even nationally or even within yourself, you will be able to assist the parties who really want to resolve the disputes. Two, sometimes, many a times you need to do pro bono activities, awareness activities through education institutions or through NGOs, that is am I audible? Non-government organization. And then you need to spread out awareness programs within students in college institutions about what mediation is. Now, how you want to make your career is starting from your student days to your professional days. When the clients come to you, first and foremost, do not push them towards litigation. Ask them an option whether you really want to settle the dispute. If they really want to settle the dispute, then you must enable them to move forward the strategy towards mediation. or towards arbitration or conciliation, depending on which wing you want to choose of ADR. Now, fourth important point which I would like to put forward is many a times your clients are very uncomfortable in speaking up things of what their dispute is. So it will be your role if you are very good with reading psychology. So mind reading is very, very important, and accordingly advise them of what is best suitable for them, either court litigation or either mediation. So once you have the skills enhanced in yourself, the success story is there. 2 or 3 matters you try and settle, you will get 30 to 40 matters because people will start knowing you, people will start recognizing you. So with all these things, you need to have experience. So sometimes you say, how do I get the experience? Do I get it just as a fresher? I will definitely not get. Try assisting some well-known mediators, try assisting some well-known arbitrators in their matters. Try to get that enhanced opportunity, maybe paid, unpaid. Don't go for the money. Don't go for just making your financials high. First, go for a situation where you can learn and you can devote your time to best of the utility that you can do, so that people benefiting out of you who will be taking your advice or will be coming to you will get the right roadmap of what their disputes can go through and what they cannot go through. So for that, you need to be well acquainted with the subject. Thank you.
Thank you. Thank you very much for that. Thank you very much for that wonderful contribution. I really wish that I had that opportunity to I had the opportunity to hear from distinguished mentors like this when I was about to start my career in ADR. It would have helped me very, very much. Those knowledge are wonderful. Thank you very much for that. Eunice, are you with us, Eunice?
Yeah, I'm still here. Okay.
Okay, so Mary will ask her question, then you make your contribution and attempt her question.
Can
okay?
Good evening.
Can I quickly add that I will appreciate if we allow Eunice contribute to the last question before Mary takes her question. Please, if you don't mind,
okay.
Please.
As Ambassador has spoken, so it is. Eunice.
I beg.
All right, thank you, Samuel, and thank you, Nanchang. Okay, I think Ambassador had actually covered everything, and my learned friend from India had really covered the field. But what I would just like to add, because many people will be thinking, especially students now, that I'm just finishing from school. Do I want to start up on my own? It's not easy to be an entrepreneur. Where will I start from pro bono and all of that? But this training is arming you with so much skill that is applicable anywhere you see human being. Anywhere people exist, then the skill of a mediation sells. It's how you want to apply it. I've seen the question, somebody say, what other opportunities in the ADR sector? Maybe when you're looking for job, because like, how many pro bono will I do? All of those are very, 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 very key in getting experience. It's not just about you coming and learning and you just pocket, you have to practice it. So anyway, like I mentioned, maybe when you're looking for job, look for roles. Don't just look for the title, because you may not see the title of mediator. When you see the title of mediator, most mediation role or mediator role are next to maybe an NGO, multi-door courthouse. But how many multi-door courthouses do we have? And the process of even getting in there is not as easy as we may portray it. And most of the mediators work now, I've not really seen any courts that has mediator on full time. They are most time freelance. When there is case, they call you. But if mediation is your sole source of income, it may pose a challenge. So for people that may want to look for a 9-to-5 job, you may want to look at the job descriptions and be able to now adapt the social skill you are gaining from mediation to the role. Am I still audible?
Yes, ma'am.
please.
Yes.
Yes,
So
ma'am.
take for instance, I'm working currently as a conciliator. I have never gone for any specific training as conciliator. But if you look at the role of a conciliator and a mediation, is the same thing. So you just adapt and copy it. This is as a conciliator, this is what I've done, this is what I've done, because it's the same skill that is required. If you look at job role like ombudsman, it's the same role. It's the same thing that you do, the same training you have as a mediator that you need as an ombudsman. If you look at some of the role in HR, human resource, it's conflict resolution. Even in business analysis, you are resolving conflicts. So don't just look at the job title. Look at the job description and then fit in all the skills that you are acquiring from this training into that role. And you will see that you get multiple invitations for the job. Investigator, as the mediator, you investigate. Yes, we say we don't investigate, but when you are probing, you're trying to get into the roots of the case, of the matter, to be able to resolve it. So you're doing a lot, and there are a lot of opportunities only if you can adapt the skill you are getting into that. That's just in addition to what everybody had said about you putting yourself out there, write articles. If you are not on LinkedIn, like we used to say during service, then you are very wrong. Go and create LinkedIn profile. Follow people that are doing what you are doing and post. Write meaningful posting on LinkedIn. Connect with people, volunteer, and most importantly, learn to and be positive. I think that's the key thing. People will say, oh, there is no job called mediators. It is that. No. You tell yourself, I have learned, I've gone through this training and there is job for me. It may not be called mediation job, but you have the skill of a mediator, you have the skill of a problem solver, and you need it in every field. Everywhere you go to, you need that skill. So there are jobs for you out there. Just be positive. Thank you.
Thank you very much. Thank you very much, Eunice, for that wonderful contribution. I hope the mentees are taking note and that they are not maybe cooking or jumping from here and there. They are actually listening and taking important notes. It's a rare opportunity, a rare privilege. If this thing is organized under career opportunities in ADR and it is charged, you will pay a lot of money before you attend the session. So but you can see some of this advice from distinguished speakers all over. Eunice is in Scotland, Kapadia is in India, Orobosa is in Edo, I am in Kaduna State. So you have you have perspectives from almost all around. So you're actually fortunate and privileged. So having said so, thank you very much. Group, is it group 5 or 4 that did the presentation? Who is the person who prepared your slides? Who prepared your slides?
Mr. Musonda, sir.
So, sir. You said Mr.
Musonda, Mr. Musonda, sir.
Musonda.
His name, sir, is Mr. Musanda.
Is it Musanda or Misanda? Okay.
Mr. Musanda.
Musanda. So you see, one of the things you will do is reach out to some of the mentors or reach out to someone and say, please, I want to volunteer to assist you do maybe your ADR related matter. I can do research for you. I can do this. I can do that for you. You know, I have these skills or that skill. You know that what that does for you is you are going to have access to a lot of materials. You are going to have access to a lot of knowledge. And let's say if the person is going to speak somewhere, if it is virtual, you say, oh, I have my assistant with me, please. You know, opportunities that you have to pay for because of the person you are with, you can easily have that opportunity to, you know. So these are some of the things you should take advantage of. If you have skills, you have abilities, you have knowledge, you have been trained, get someone who is in that field that can lift your hands up. That's very, very important. Take note of that. Then Mary, that's the person with the last question in the house. Mary.
Good evening, everyone.
Good evening.
Please, can you guys hear me?
Yes, we can hear you.
Okay. So, please, I have two questions. The first one, how flexible and how realistic is it for a person, for example, who's an accountant, to mix being an accountant and being a mediator together? And you're working like a 9 to 5 job. In reality, how realistic is it? Then question two, the presentation we're told that a mediator will give his or her award. This award, that's like, should I say like judgment or so? Is it like for law now, for like past precedent that the person will follow, or like a guideline to know, okay, if this type of thing happen, this is how you go through? Or is it like with the discretion of the mediator? So I just want to know like how an award is given. Thank you very much.
Okay, Ambassador Samuel, that question is directed to you, sir.
Thank you so much, sir, for the privilege. It's actually directed to us. In the normal patterns, we have been to ladies first, but I think now, Mr. Nathan, you are calling me to men first. I hope the ladies, the female mentors will forgive me that I'm always taking the first shot before they come on board. Mary, if you don't mind, can I confirm, what is your discipline, please?
I'm actually a law student, so I just
All right.
put like accountant, for example.
Okay.
Thank you.
We are always glad when we understand that ADR practitioners have a clear primary base. One of the constraints we're actually having now among practitioners is that people fail to build their core competence. In every professional field, you know what we call area of specialization. Now, as an accountant that doubles as an ADR practitioner, it therefore means he can offer his competence in financial related matters. Now, your question is based on how can I manage my financial profile with an 8 to 4 job and also providing my ADR services. Now, don't forget, you can provide your ADR services as a mediator. You can provide your ADR services as a mediation advocate. You can provide your ADR services as an ADR consultant. You can provide your ADR services as a trainer. You can provide your ADR services as an ADR resource expander. Now, I'm sure we will have time to go into details in each of these. Now, that means when you have your 8 to 4, 8 to 5 jobs, you have your leave. You can have 1 hour or so to do whatever it is you want to do. Now, most of us that are speaking with you, we have our 8 to 4 jobs. We have our 9 to 5 jobs. But we also find a way to do the needful at the right time. It all depends on your network and your ability to leverage on your opportunities. I don't know if I've been able to go down well with that answer. But now shifting to the other base, that I want to focus on an area so that the other mentors can come in. Going to the other base, I'm not too sure I heard you correctly, or I'm sure maybe you meant something else when we're speaking about mediation and award. In my mind, I think you're actually making reference to mediation. Mediation, we have settlement agreements. That is the outcome of a mediation process. If the parties are willing to resolve, award is tied to arbitration. So for me to go forward, I need to confirm from you, are you speaking about settlement agreement in relation to mediation, or you are speaking to award in relation to arbitration? Could you
Sir,
please help me?
that would be settlement agreement. Sorry for the mix-up, sir.
No, we are all in the learning process. You know, in mediation, we have been told that nothing is actually wrong if you can prove your point from your unique perspective. Now, one of the beautiful things about settlement agreement is the fact that it is a product of both parties. It is whatever the parties decide at the end of the day under the guidance of the ADR practitioner, under the guidance of the mediator. So we may not be able to have precedence because we know that in mediation, no two matters are the same. Let's assume the parties are the same. No two matters are unique because there must be one variable for one to the other. So no matters are the same. No precedence in mediation, but there are some skills that you can acquire. There are some lessons you can acquire from a particular mediation session that will further equip you and brush up your skills to become more efficient and diligent in your services. The major role of the mediator when it comes to the settlement agreement is helping parties structure the settlement agreement in such a way that it can reflect what the settlement agreement ought to be. The context, the content, the structure is what both parties have agreed on. If it's a contractual matter and there was a default in rendering of services, now, is one party agreeing to do the needful at a later date? If yes, it is structured when it will be done, how it will be done. If it's a debt recovery issue and parties have agreed, oh, I know I owe X, Y, Z. I'm going to refund X, Y, Z in such and such installment. This is the number of installment. Is it going to be on equal installment basis? If the amount involved is 2 million, am I going to make refund of 500,000 in 4 installments? Or am I going to make 1 million first installment, then the other 2 installments, 500,000? Over a period of time, there may be interest elements. The claimant may wish to let go the interest element completely or have a reduction. So you see, the settlement agreement reflects the position of the parties. In mass, there's also intercession. At what point did they intersect? How much of their rights did they let go? So what happens for A may not happen for B. So the settlement agreement, as it were, is a simple document expressing the terms and conditions the party have decided to let go of their animosity. And like Eunice said much earlier, if we stop at settlement agreement, parties make their way and they just shake hands and go by and sign it. That is okay, but it's usually ideal if that settlement agreement is being processed and worked upon to become what we call consent judgment. Consent judgment is like the judgment of the court. It is even stronger than the judgment of the court because these are the terms of the parties and it becomes enforceable. If for any reason one party defaults, don't forget that they have signed, usually in most cases, for matters that go through mediation, when it's being processed and it gets to the table of the judge, the honorable judge may decide to call the parties just to confirm. Is it true that both of you signed this? Were you compared? And they say, no, we were not compared. Okay, it's been processed. Now, if there's any issue at the end of the day in terms of implementation enforcement, all the party needs to do is to go back to the court of the judge that does this. Now, it is so unique these days that even parties that do not come to the multi-court courthouses, some private disposition centers, they have an understanding with multi-court courthouses that any agreement reached at their centers, they can forward that settlement agreement and the parties will just pay a little token to the multi-court courthouse. So instead of going through the lengthy process from beginning to the end, they can just go through an abridged process to confirm if that settlement agreement actually reflects their position. If it does, it is being moved along. So the same way you enforce court judgment,
In the same way you enforce a settlement agreement that has been processed to become a consent judgment of the High Court. What does it mean when we say consent judgment? At the level of the multi-door courthouse or any dispute resolution center, it's called settlement agreement. But when it proceeds and is being upgraded from that level to becoming a consent judgment of the court, it becomes court property. So the honorable judge can enter it in her record book and claim ownership. This is my judgment, and take responsibility for it. I don't know if I've overflowed the issue, but it is wise that I stop here and allow other mentors of the call add more flesh to whatever I say. No one has monopoly of knowledge. Thank you so much for this privilege.
Thank you very much, sir, for that wonderful contribution. I think you have summed everything up. I will only say that those who are in this class or in this mentorship are fortunate, because the essence of our coming together and trying to see how we can establish this mentorship is so that we can create a comfortable platform for migration of students and professionals into the professional space. And Settlement House ADR Training Institute is an institution that trains and certifies in mediation, arbitration, negotiation, and all the ADR spheres. And so mentees in this particular training and mentorship are actually have the privilege and the opportunity to actually take up our certification matters, take up our certification training, if it is mediation and arbitration. We have one of the training that is coming up, and because of the arrangement we have made, mentees of this session are actually entitled to whatsoever the fee is. They are going to have like 50%, and we have the fees for students and then the normal ones. So if you are a student or you are a professional, you have opportunity to take up this training. So what I will say is, for those of you who are interested in taking the certification training in mediation, please, you can drop your names on the platform so that we'll reach out to you. We are going to share the flyers and some of the information that you need. I think you should take advantage of that opportunity. If you have any issue or difficulty, feel free to reach out to us. We are there to see how we can guide you and assist you to become the professionals that you are. And in conclusion, I want to say that we are looking forward to specialists. We are looking for subject matter expertise in ADR. Those subject matter expertise, if you are a lawyer, you specialize in oil and gas, we need you to come out as a mediator that specializes in oil and gas. So if you are an accountant, you are a mediator that specializes in financial issues. You know, when you use your ego, you will see malpractices in places where even a lawyer will not be able to. That is expertise, right? So please, whatsoever field you are, you can function. If you are a medical doctor, you can become a medical, you can become an expert that specializes in resolving medical-related disputes. In fact, when it comes to appointment, they appoint you based on your expertise. Parties may have a requirement. We need a lawyer with 15 years experience in so field. So develop that field that you are. You know, any field at all. If you study CRS, you can concentrate on resolving religious-related matters. If you are a Muslim, you can specialize. In fact, in our training, we have introduced Islamic mediation. We have an expert in the field who is going to come and talk to our participants about Islamic mediation. You can decide to say, oh, I'm a Christian, I want to help people resolve issues that relates to Christian relationship, church, and the rest of it. So these are all, in fact, the opportunities are all there. And I used to tell people, see, when you study any course, that course will equip you to become a better ADR practitioner. That is what I tell people. So when you are staying there and looking for employment, instead of looking for employment, you finish finish your degree or your HND or whatsoever, go and open an office and say you are a specialist in resolving disputes in your own field. Start up from there. And those of you who are students, you are fortunate. Start up now to begin to let your brothers and sisters, that's why when you take up the certification training and you are certified early, begin to advertise this thing. Open up a LinkedIn account, as somebody, one of the mentors has said. Your social media handles should be filled with information about ADR. Let your friends, let your family members, let people around you get to know that you are into ADR. And since you are a microbiologist, you are concentrating in seeing how you can resolve dispute in that field. You're a pharmacist. There are issues with fake drugs, this and this. These drugs has caused this issue. It has affected this person and that, all of those kind of things. When you finish as a pharmacist, instead of looking for a job from one place to another, you are already a specialist in a medical or a pharmaceutical line. Tell them that you are a specialist in resolving disputes in your own field. Then open up your office. Meanwhile, those that are still in school or belongs to professional association, let them get to know that when they are looking for someone that will help them resolve dispute in their field that involves them or the things that they do, you are the first point of call. That is how to market yourself. So I will count you. I will say that you are privileged to have been listening to these kind of things here. And don't forget, drop your name on the group chat. If you are interested in taking up the training, we'll share with you the flyers. I think with this, we have actually come to an end of this program. Mr. Samuel has something to say, and then I'll hand over to either Sophie or Dennis to conclude the session.
Yes, just to quickly add to what Mr. Nutmeg said, open your office can take different forms. You can work remotely. You can have an online office. So you may not have the facility or the resource here to have a physical office, like an office space. It may be quite expensive. You can have, on a very practical note, in my accommodation, I have an office in my accommodation. I have my own office. The whole world is a global village. So you can dedicate a space in your accommodation, a space in your room, get your background, start off something. Be social media savvy. You never can tell where you will go from there.
And we are all here to assist you in any way that you may need,
It is not how much you have, but how much you are willing to give in as far as this thing is concerned. Then finally, on the final note, be genuine with your style. You don't need to look like somebody else. You don't need to copy somebody else. Be genuine in your style. Your genuineness will help you stand the test of time. Thank you so much.
All right, thank you very much. Dennis, if you are there, or Sophie, over to you.
All right, thank you very much, sir. And thank you to all our mentors for a wonderful session today. Basically, our mentees were the ones who did the presentations, and our mentors just took charge and gave answers to our questions. And I'm sure our mentees were able to learn quite a number of things from our mentors today. Thank you to Mrs. Kapadia in absentia. I think her time zone is quite late. It's quite late in her time zone, so she had to leave. Thank you to all our other mentors that were able to join in. Miss Eunice, I can see she's also not here. Thank you to Mr. Samuel, and thank you also to Mr. Nyasham for such a wonderful and interactive session. With this, we've come to the end of today's session. Look forward to seeing you in next week's class, right? And with this, I will say good night and take care, everyone.
Please ensure you tag your mentors, tag Shati, tag JIIPCC, when you are making your posts. Thank you.
Yes, thank you, sir. Thank you for that reminder. So please do not forget, when you are posting what you've learned in today's class, make sure to tag Shakti, Settlements House, ADR Training Institute, tag JIIPCC, right? And then also tag your mentors, right? So good night and take care, everyone.
Thank you very much. Good night.
Good night. Thank you very much.